because that's how you get shot by the police.
We're the Armed Attorneys. Today we're talking about what to do after a defensive incident, after you've called 911, but before the police arrive. Stick around to the end for our pro tip on how to ensure you have attorney-client privilege. And before we get started, show your support for the Second Amendment by hitting the like button.
And to kick things off, we have to make a couple assumptions like we do in most of our videos. The scene is safe. You've already made that critical 911 call. Check out the description of this video. We have a whole breakdown on how to call 911 following a defensive incident. And now we have to figure out, what do we do before the police arrive? Now, first things first. Again, scene safe. What are you doing with that firearm following a defensive incident, Emily?
Yeah, I think I can start by saying what you're not doing. You are not altering that firearm in any way. Some states have much more restrictive tampering with evidence laws than others. We don't ever want to invoke that. So you hear sort of internet rumors about disassembling weapons, unloading. Don't do any of those things. Leave it in the condition it was the last time you pulled the trigger. And then probably you want to get it out of your hands, right, Richard?
Yes. You know, the worst thing, that's how you get shot by the police.
Oh, yeah.
When they arrive on scene and you have a gun in your hand. That's what we see from time to time. So we don't want the firearm to be in your hand. Again, assuming the scene is safe. Now, what do we tell our clients when they find themselves in these situations? Depending on the circumstances, placing it on a kitchen table. Let's say the defensive incident was inside your house or on the front porch, or let's say it was, out in public in your vehicle. Maybe it's sitting on the driver's side seat. You're standing outside of your vehicle. We just don't like it when the gun's in your hands when the police arrive.
Yeah. Reholstering on your body, if that's where it came from, completely acceptable. Some people, it makes them uncomfortable. They don't even want it on their person when police arrive. Totally understand that. However, I've seen probably over 100 clients reholster before police arrive and have it turn out perfectly fine.
Yeah, that's also a very viable option. Now, once we scene safe, firearm is in a location that's going to increase our safety when police arrive. What are we doing next? We're trying to speak to our attorneys, wouldn't you say?
Yeah, so if you have an attorney to call, that's great. Do it. Get their advice, follow their instructions specifically. A lot of people don't have that attorney, though.
No, and that's where if you just follow these two steps, we're going to do a whole video breakdown of what to do once the police arrive. But if at this point, let's say the police show up, if you're invoking your rights, invoking your right to remain silent, invoking your right to an attorney, you're going to start off better than 99% of people who are maybe a suspect in a criminal investigation. So invoking your rights if you haven't spoken to your attorney.
Yeah, politely. But firmly.
And that brings us to our attorney pro tip of the day about how to maintain attorney-client privilege and confidentiality. And what do you have to tell folks about that?
Yeah, so there are a couple things. The first is, if anyone can overhear what you're saying, you do not have attorney-client confidentiality. So you need to put yourself in a physical location when you call that lawyer where no one else can hear you. And so that's number one. Number two is that the client has the option to waive that privilege at any time, right? We don't have that option. But you as the client, you can tell anyone you want what we talked about. It's a very bad idea, though, because once you repeat that conversation to anyone, that other person now can be called as a witness to talk about what it is that you said. And I know people are going to say, oh, that's hearsay. But when you're a party opponent, right, when you're the one who's either charged with a crime or you're being sued civilly, your statements come in.
Yeah, and this happens, we see it happen from time to time. Have a client who's been involved in a defensive shooting. They get their attorney's advice and they maintain confidentiality up into that point. And then, they just want to be reassured. They want to get a second opinion. They want to talk to a friend who's maybe a current law enforcement officer or a family member who's maybe retired law enforcement, just to be reassured, hey, did I do the right thing, and get that opinion. But what they don't understand is now that family member or that friend could be called into court and ordered, compelled to testify. What did the defender say to you? And so it's really important. That's why we tell everybody, don't talk about the defensive incident with anybody. Don't post on social media. Don't talk to anybody about it except for your lawyer. But I hope you found this discussion helpful. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And we get this question all the time. What can we do to help support the channel? Consider becoming a channel member, hitting us up on YouTube, Subscribestar, or even Patreon.
And as always, we always enjoy your question and comments below. Keep them coming. Until next time, we're the Armed Attorneys.